Moving on, as there are multiple parties involved in these transactions, there are bound to be scenarios when there are disputes between them with regards to their rights in using or providing appropriate compensation to the other parties. So who is responsible for resolving such disputes? As per section 103, parties can approach High Court for seeking its assistance in resolving the disputes. So what disputes are we talking about? As per section 103.1, there could be a question if the government actually is right in exercising its option as per section 100 for using the invention for its purpose, or with regards to the terms of using the invention by the government for its purpose. There could be dispute with regards to the rights of a person in receiving part of a compensation, or the amount of compensation that needs to be paid by the government to the other party. The High Court can help the parties in resolving such disputes. In fact, the High Court can refer out the entire proceedings or a part of the proceeding or an issue or question to an official referee or a commissioner or an arbitrator as per section 103.5. So the High Court can take outside assistance as well. Now let's look at the proceedings from the point of view of the central government. As per section 103.2, the central government can file a counter claim for the revocation of the patent using the grounds as per section 64. If not that, the central government may question the validity of a few claims without petitioning for the revocation of the entire patent. Moving on, remember, the government will not pay any compensation if the invention was known to the government before the priority date of the claims. Now, to prove this, the government is required to provide evidence of such documents or any trial and testing that the government had done before the priority date of the claims. There could be scenarios where the government is of the opinion that they cannot provide such an evidence in public forum. So they may confidentially provide such an evidence to the advocate of the other party or to an expert who has been appointed by these parties as per section 103.3. Moving on, in case the inventor or the patentee was a government employee, the central government or the state government or any government undertaking, and the subject matter of the invention relates to the work that the inventor did while he was an employee of the government, then the central government has the power to dispose of the disputes on its own while providing appropriate opportunities to the other parties. Finally, let's look into the proceedings from the patentee's point of view. In case the dispute is with regards to the terms of use of the invention for the government purpose, so while deciding the dispute, the High Court takes into consideration the compensation or the benefits that the patentee or any other person may have received or is entitled to receive for the use of the invention by the government for its purposes, so that the terms and the compensation are justifiable to the patentee as well. So with this, we are done learning the sections 99 to 103 that talks about the use and acquisition of the invention by the government for its own purpose. So I hope this was useful for you, and now you have clear understanding of section 99 to 103. So until next time, take care and be good.